If you've ever applied for a U.S. visa, you might have heard the term dual intent. Many people don't know or understand this concept, so let's break it down. Dual intent is a U.S. immigration law concept that generally refers to the fact that certain U.S. visa categories allow foreigners to properly maintain lawful non-immigrant status in the United States and have the intention to immigrate or seek permanent residence in the future. Most, but not all, non-immigrant visa categories require an applicant to demonstrate temporary intent to live in the U.S. These applicants usually bring proof of permanent ties abroad to their visa interview, showing, for example, that they maintain a residence or family abroad, have a return trip ticket back to their home country, or a temporary work engagement in the U.S. These single intent categories include B1 and B2 visitors for business and tourism, TN NAFTA professionals, E1 treaty traders, E2 investors, F1 and M1 students, and J1 exchange students. Other non-immigrant categories explicitly allow a foreign national to obtain temporary non-immigrant status and, at the same time, lawfully seek to become a permanent resident of the U.S., that is, obtain a green card. These categories include H-1B for workers in specialty occupations, L-1 intercompany transferees, O-1 foreigners with extraordinary ability, K-1 fiancés, and the dependent family members for these categories, like spouses and children under 21. Dual intent visas allow foreign nationals in the U.S. to have two things in mind at once: temporary and permanent intent to live in the United States. I'll admit that the doctrine of dual intent is not entirely the most logical concept. However, this is not to say that single intent visa holders can never obtain a U.S. green card. They will, however, have to tread carefully, and they will have various timing considerations to take into account. Let's look at the example of a TN visa holder who is working in the U.S. and whose employer wants to file an employment-based green card on his behalf through the PERM process. We first want to ensure that when the TN was granted, the employee's intent for the work was in line with being a temporary non-immigrant. However, he's not automatically precluded from developing immigrant intent at some point in the future. One critical distinction is that he must not have taken affirmative steps towards those plans at the time of applying for the TN visa, or following any particular reentry to the U.S. An employer could technically begin the lengthy PERM process over the course of 12 months, and this would likely not have any impact on the employee's underlying status. After the PERM is approved, we really want to carefully strategize the next steps for the I-140 immigrant visa petition and the I-485 adjustment of status application, or AOS. Filing a green card application with U.S. Citizenship and Immigration Services obviously indicates immigrant intent. Even if the application is approvable, the applicant must worry about maintaining underlying legal status in the United States. Timing becomes important to assess the full case strategy for the next year or two. First, we would never want to file an AOS application for a TN holder who has frequent international travel needs. AOS applicants with single intent visas are restricted from international travel with the AOS while the AOS is pending, until a travel document called advance parole is issued. We also wouldn't want to file an AOS within 90 days of his last reentry to the U.S., as this might indicate fraudulent intent at the time of entry on his single intent visa. If the applicant doesn't have these issues to address, we next want to look at how much time is actually left on the underlying TN status to ensure there wouldn't be any gaps in lawful work authorization while the AOS is pending. While advance parole travel authorization and interim employment authorization are issued as part of the adjustment of status process, these documents can take quite some time for issuance by USCIS, and they're difficult to expedite. If either one of these restrictions are a concern, consular processing in the applicant's home country might be the best route to finalize the green card process. At the end of the day, my message is this: don't rule out your green card path just because you're on a single intent visa. It can be done with careful strategizing and guidance from an immigration attorney. If you have questions about your underlying non-immigrant status and dual intent restrictions, contact Berardi Immigration Law today and let's chat.
Thank you so much for watching. Be sure to like this video and consider sharing it with a friend. For the latest immigration news, check out the Berardi blog at berardiimmigrationlaw.com. And don't forget to subscribe so you never miss a video from Berardi Immigration Law. Until next time, have a great day.